Thank you, Mr. Chairman, and let me thank all of our witnesses today. Mr. Smalls, you mentioned in your testimony that in addition to firing you, Amazon also fired Gerald Bryson, who was one of the other protest leaders. Amazon claimed that Mr. Bryson was fired for statements he made in an argument with a coworker. But here's how an NLRB administrative judge described Amazon's review of Mr. Bryson's conduct that led to his illegal firing. And I'm quoting now from the judge. An ostrich-like head-in-the-ground investigation that seeks to avoid evidence which might disclose information mitigating the employee's misconduct, unquote. In other words, Amazon deliberately ignored the facts, deliberately misrepresented the situation, and that's why the NLRB ordered Amazon to reinstate Mr. Bryson with back pay and found that his termination had been wrongful. So, Mr. Smalls, you know Mr. Bryson. Why do you believe, why did Amazon fire Mr. Bryson?
A few things. Number one, he's black. Number two, he was protesting alongside with myself and others over COVID-19, which was running rampant at the time. New York was the epicenter. So they wanted to, once again, silence the organizers that were advocating for that, myself included. You know, I'm still unemployed as we speak.
And when a company like Amazon takes that kind of action in retaliation for a protest, does that make it more difficult for you to organize?
Of course it does. It's an intimidation factor. You know, if they fire the people that are speaking up, everybody else wouldn't want to come forward because they think it's going to happen to them.
Yeah. So, you know, and here's the thing about our system. It took 2 years or a little longer than 2 years for this particular case to wind its way through the NLRB and get a decision from an NLRB judge. And you know, by that time, the damage is already done, not just to the person wrongfully fired, but also to the organizing effort. We've just got to dramatically improve this system, and that's why we want to provide additional resources to the NLRB and make other reforms. You know, I chaired a hearing just earlier this week in the Appropriations Committee. I chair a subcommittee called the Financial Services and General Government Subcommittee. And I discussed with the IRS Commissioner the fact that we already debar, we already prevent federal contractors who don't pay their taxes from getting government contracts, right? It makes sense that if you're not paying your taxes on time, you shouldn't benefit from a contract where the taxpayers are funding it. We also will hear later from a GAO witness on the second panel that federal contractors can also be debarred for violations of the Service Contract Act. And the existing federal acquisition regulations provide for debarring federal contractors for any offense indicating a lack of business integrity or honesty. Mr. Leroy, given that we already have these provisions in place for violating tax laws, service contract laws, and other circumstances, why wouldn't we also say that for contractors who are engaged in serious violations of labor law, that they would be prohibited from getting federal contracts, at least for some period of time?
I wholly agree, Senator, and I'm proud to say that I'm a Maryland resident, and that you represent us very well. Looking at the debarment criteria for some of the General Services Administration, even state governments, they all have procedures. We're simply saying we want to elevate labor law to the same magnitude and significance as tax law or integrity law or antitrust law, and I think that's a very reasonable thing to do. It's saying we care about workers, and we're not going to pay companies to degrade workplaces, suppress wages, make inequality worse.
And just in my closing seconds here, Mr. Spencer, and maybe, I mean, do you disagree? should we have a carve out? In other words, and I'm talking here where we would agree that there's been a significant violation of labor law, right? Would you agree that that is the kind of violation that, at least for a period of time, should disqualify a contractor from getting a taxpayer-funded contract?
Well, what I would say is I think I agree with your point that there's a procedure in place currently under the federal acquisition regulations to determine whether a contractor is suitable to receive a contract. I used to work in the federal government, so I knew contracting officers when I was there. I still know some of them now, and I trust those folks to use their best judgment when evaluating a contract as to the suitability of an individual contractor. I just point out one thing here, not to talk about Amazon, but one of the things that they did during the pandemic, as we recall, there was a dramatic expansion in the unemployment insurance system to provide benefits to people who were out of work. AWS helped some of the states deal with the computer upgrades that needed to happen to make sure that those benefits could be paid on time and to people who had earned those benefits. So if you're limiting the ability of companies like that to provide those vital services, that's going to inhibit the ability of people to collect the benefits that they've earned. So I would say that I think contracting officers can make those evaluations and can use their balanced judgment to determine whether somebody a company is suitable to receive a contract.
Right. We shouldn't have a situation where gross violations of labor rights are actually treated differently than gross violations of other law that bar people from getting contracts. I see I'm over my time. Thank you. Thank you all. Thank you, Mr. Chairman.